If you're just joining us, the Speaker of the Senate has ordered the quorum bell to be rung for 10 minutes. And what happens in the background is that respective leadership of the House mobilizes members to walk into the chambers to allow the House to attain the requisite quorum to enable business of the Senate to proceed this morning. The invitation to the National Assembly to appear and be represented before the Senate during its investigations was served on the advocates for the National Assembly on Wednesday, 9th of October 2024. The invitation required the National Assembly, if it chose to appear before the Senate, to file with the Office of the Clerk of the Senate by 5 p.m. on Monday, 14th of October 2024, a soft copy and 80 hard copies of documentation designating the members of the National Assembly being not more than 5 members, if any, who shall attend and represent the National Assembly in the proceedings before the Senate. 2, indicating the mode of appearance before the Senate, whether in person, by advocate, or in person and by advocate. 3, indicating the names and addresses of the persons to be called as witnesses, if any, and witness statements containing a summary of the evidence to be presented by such witnesses before the Senate. And finally, specifying any other evidence to be relied on. The invitation to appear and the affidavit of service is contained in the documents that the senators will be given for their perusal as they consider the impeachment motion that was filed against the Deputy President. Now, on Monday, 14th of October 2024, the Office of the Clerk of the Senate received a response to the invitation to appear by way of a letter dated 14th of October 2024 from the Clerk of the National Assembly, informing the Speaker of the Senate that the National Assembly would appear before the Senate in person and by advocate. The following members of Parliament had been designated to attend and represent the National Assembly in the proceedings. 1, Honorable Dr. Otiende Amolo, Honorable George Murugara, Honorable Samuel Chepkonga, Honorable John Makali, Honorable Zamzam Mohammed. The team of advocates representing the National Assembly are as follows: Honorable James Orengo, who is the lead counsel, Mr. Paul Nyamodi, Mr. Gumbo Eric, Kipkogei Moses Kipkemoi, Mudomi Thiankolu, Peter Wanyama.
Take your seats, Honorable Senators. I'm informed we do have quorum now, so we'll proceed with our session. Clerk, proceed to call the first order, please.
Order number 1, communication from the chair.
Senator Karungo and Senator Mtata, kindly take your seats. Now, Honorable Senators, I have a communication to make relating to the business of the Senate, as scheduled for consideration during this very solemn sitting. You will recall that at a sitting of the Senate held on Wednesday, the 9th of October 2024, I appointed today, Wednesday, the 16th of October, and tomorrow, Thursday, the 17th of October 2024, as the days when the Senate will hear the charges and investigate the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, the Deputy President of the Republic of Kenya. Now, Honorable Senators will also recall that at a sitting of the Senate held on Wednesday, the 9th of October 2024, a procedural motion for the alteration of the sitting time of the Senate for Wednesday, 16th, and Thursday, 17th of October 2024 was moved and approved to facilitate the impeachment hearing of the Deputy President of the Republic of Kenya. Subsequently, via the Gazette Notice number 13178, I notify the general public that pursuant to Article 145, subsection 3 of the Constitution, and Standing Order 781 of the Senate, the Senate resolved to investigate the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, AGH, Deputy President of the Republic of Kenya, in plenary. Now, Honorable Senators, regarding the hearing and determination on the proposed removal from office by impeachment of the Deputy President, a program has been prepared and appended to today's order paper. As is the tradition, and in line with the schedule of activities for an impeachment hearing in plenary, the Senate will hold a closed-door preparatory session to deliberate on the management of the investigation. The objective of the preparatory session is to ensure that the process is conducted seamlessly, concluded timely, and in line with the requirements set out under the Constitution and the Senate standing orders. Honorable Senators, during the pre-hearing, the parties, if they are present, all members of the public and the media will be expected to withdraw from the chamber and the galleries, and any form of broadcasting from the chamber shall cease forthwith. In accordance with the program for the impeachment hearing, the open session will commence at exactly 10 a.m. Consequently, I now direct all members of the public and the media to withdraw from the chamber and the galleries, and any form of broadcast from the chamber to cease forthwith. Kindly be guided accordingly. Thank you.
To be prudent that these courts allow at this time that we can file an amended petition. On the second issue of the mention of strike, the outcome is two. The deputy president can either be impeached or the charges before the Senate might be dropped so that they are not confirmed. So that it will also be important for the court's program to know what is the outcome of this particular matter that is of great public interest. The mention of Friday will therefore help in updating this honorable court on the outcome of that particular process for the Senate, so that
the proposed removal from office by impeachment of His Excellency, the Deputy President. By a message received in the office of the Speaker of the Senate on Wednesday, 9th of October 2024, the Speaker of the National Assembly informed the Speaker of the Senate of the approval by the National Assembly of the motion for the removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya. By a letter dated 8th of October 2024 and received in the office of the Speaker of the Senate on Wednesday, 9th of October 2024, the National Assembly submitted documents and records of the proceedings in the National Assembly. Among the documents which were submitted by the National Assembly include the notice of special motion and affidavit of Honorable Ekomas Mwengi Mutuse, dated 26th September 2024 and received on 27th of September 2024, running from page 40 to page 42. Also submitted by the National Assembly electronic evidence relating to the special motion contained in a flash disk, order paper for October 1st, 2024, communication from the chair, number 046 of 2024, issued on 1st of October 2024. The communication from the chair, number 046 issued on 1st of October 2024.
No particular president by any direction that has been given.
Other documents that were submitted by the National Assembly included the certified counsel and votes on proceedings for
a ruling which will be perfected in the course of the day, but whose summary is as follows. We have given the facts of the proceedings, the relevant submissions and arguments, and for the purposes of today and this morning, because we don't have much time, we'll give you the abridged version of our ruling. Analysis: having carefully considered the applications, the responses, the party submissions, and the various decisions referred to, the court distills the following issues for determination. 1. Whether the applications are res judicata. 2. As to whether the applications are judicata, the nature and applicability of the doctrine of res judicata is a well-trodden path by the Kenyan courts. In petition numbers 42 and 43 of 2014, which were consolidated, that is Kenya Commercial Bank Limited versus Muri Coffee Estate Limited and another, the Supreme Court of Kenya, in an elaborate fashion, illustrated the operation of the doctrine of res judicata. We are not going to go into the details about the doctrine of res judicata, but we have considered it there. We have cited several cases in support of the arguments put forth by parties. And returning to the matter at hand, there is no contestation that the first petitioner herein, Rigathi Gachagua, filed and prosecuted an application seeking conservative orders in Nairobi High Court Constitutional Petition number E 550 of 2024. On 15th of October 2024, His Lordship Judge Muita delivered a ruling on that application. For reasons contained in that ruling, the application was dismissed. The nature of the conservatory orders which were sought in the said Nairobi High Court Constitutional Petition number E 550 of 2024 related to various facets of the impeachment proceedings against the first petitioner, in this case, before the National Assembly and the Senate. Likewise, the applications subject of this ruling also challenge the very pending impeachment proceedings. Learned Senior Counsel, Mr. Paul Muite, urged this court to nevertheless deal with the instant applications for the main reason that this court, as constituted, is an expanded multi-judge bench of the High Court as opposed to the ordinary single bench. The respondents did not, however, find favor with the above position. It was vehemently contended that the instant applications ran afoul the settled doctrine of res judicata. This court has diligently addressed itself to the above arguments. Unfortunately, we did not come across any holding persuasion that a decision of an expanded multi-judge bench of the High Court of Kenya is superior to that of a single judge. This court therefore finds that the challenges raised in the instant applications are similar to those dealt with in Nairobi High Court Constitutional Petition number E 550 of 2024. In applying the tenets of the doctrine of res judicata to this matter, we have no doubt and do hereby find and hold that the applications herein are in four corners with the one dealt with in Nairobi High Court Constitutional Petition number E 550 of 2024. The applications are hence caught up by the doctrine of res judicata. For clarity, the issues raised in the applications before us were fully canvassed by a court of competent and concurrent jurisdiction. Having found as such, and for abundance of caution and the completeness of the record, this court will still consider the second issue, and that is whether conservative orders ought to issue. As a well-settled principle in law, a court dealing with an interlocutory application seeking conservative orders is called upon to exercise restraint and to resist the temptation of making final findings at such stage. We have cited cases or authorities emanating from the Supreme Court on that matter. Therefore, a court exercising jurisdiction in an application for conservative orders must sustain that delicate balance by ensuring that it does not delve into and determine issues which largely fall within the realm of the main dispute. The nature of conservative orders was discussed in the Supreme Court of Kenya Civil Application number 5 of 2014, Gatirao Peter Munya versus Dixon Mwenda Githinji. And I have stated what the court said. It was also discussed in other cases which we have referred to in this. On the principles to be considered by courts in dealing with applications seeking conservative orders, the locus classic case of Gatirao Peter Munya, which I have said, comes to fore. And we have delved into what the court said in that case. We have also cited the case of Board of Management of Uhuru Secondary School versus City County Director of Education. We've also cited the case, the court in Wilson, Kaberia, and Kunja. You'll find them in our ruling. Having considered those, then what we then looked at are the elements for granting a conservative order. These are, we are giving them to you in point form, but we have discussed them in detail in our ruling, which we shall give. For the sake of completeness of the record, we have dealt with the merit of the application and whether conservative orders should issue, whether prima facie case has been established. We take the view that the same has been established. The applications raise constitutional issues that require further judicial interrogation. Whether any prejudice will be suffered by the applicants. No prejudice if the applications are not granted at this stage. The process is a lawful constitutional process, and the Senate will conduct a trial where all the issues being raised before the court will be raised and determined. At the moment, we are being called upon to anticipate the outcome of a process yet to be completed. The application at this stage is premature and anticipatory. Should the petitioner not succeed, the petitioner still have an opportunity to approach the court after the process. The applications are not without a remedy. On the issue that has been raised that as soon as the Senate impeaches the DP, if at all that happens, that the DP immediately ceases holding office and he cannot reclaim office, we take the view that every office holder can only assume office legally and constitutionally. The assumption of office cannot oust the court's jurisdiction. The court has unfettered jurisdiction to check on the constitutionality of the process at whatever stage. Whether the grant or denial of the conservative order will enhance the constitutional values and objectives in the Bill of Rights. We find that exercising restraint at this stage will enhance and allow independent institutions of government to function unhindered and in their fullness, except in the clearest of cases. It is our view that this is not one such case where intervention is automatic. The issues raised by the parties will require to be interrogated. We therefore find that the enhancement of the constitutional principle of separation of powers will be best served by declining the application at this point. Whether the petition will be rendered nugatory, we find and hold that it will not. The petitions challenging the process of impeachment, the petitions are challenging the process of impeachment. The substratum of the petitions will not be lost. The court is still able to grant a remedy even after the process is conducted, even after the process is concluded, and as such, the court will not be acting in vain. On public interest, we find that the public interest tilts in favor of allowing the constitutional process to proceed unhindered. Disposition, therefore. Deriving from the foregoing, the following final orders do issue. The consolidated applications are hereby disallowed, caused to abide the outcome of the main petitions. That is the ruling of the court.
My Lord, as we wait, my Lord, the ruling, my Lord, on behalf of my colleagues, I know Senior Counsel Mwite would have wished to do this, my Lord. I, on behalf of the bar, wish to thank your lordships for the industry and time that you've taken, my Lord, knowing that we left here yesterday at around 9. Lord, I have no doubt that you might not have had some good lessons. My Lord, we want to thank you for allowing us to have argued before you yesterday and for your delivery of this ruling within the time, my Lord. We will wish the Deputy President all the best, my Lord, for the Senate. I thank you, my Lord.
Thank you.
In the leadership on behalf of the first petitioner, this is Jomo for following brief for Mr. Paul Mwite, Senior Counsel, for the first petitioner. My Lord, noting that the proceedings before the Senate are virtually now commenced at 9 a.m. We don't know the outcome of that particular process, but nevertheless, would require that we appear before your lordships as soon as practically possible, and preferably, if possible, on the 15th of October this year, so that we can take directions for hearing of the petitions that are now pending.
18th of October is which day?
On Friday, this coming Friday. Senate proceedings, my lords, and your leadership will conclude tomorrow. We don't know what time, but probably at night. And it will be necessary that to protect the peace of the first petitioner, that we appear before you to take directions for hearing of the petitions. Again, my lords and your leadership, because of the unknown outcome of that particular process, it might be necessary for the first petitioner to amend the petition depending on the outcome again. So at this point, at this juncture in time, we also pray for leave of the court that if necessary, we can amend our petition before we take the directions on Friday. If leave is granted, my lords, you can comply with the amendment process as soon as possible. If you grant us time, we'll be happy to appear before you on Friday so that this subject matter is not addressed. Thank you.
Your Lordship, my name is Rigathi Gachagua for the 7th petition. Mine is just
Mr. Wathuta?
yes, Judge.
Yes.
It's just more or less a housekeeping request.
Withdraw from the chamber and the galleries, and any form of broadcasting from the chamber shall cease forthwith. In accordance with the program for the impeachment hearing, the open session will commence at exactly 10 a.m. Consequently, I now direct all members of the public and the media to withdraw from the chamber and the galleries, and any form of broadcast from the chamber to cease forthwith. Kindly be guided accordingly. Thank you.
Last week, in lodging documents at the last minute, we are seeking for permission, if need be, to lodge documents manually, just in case the CTS system will not be accessible like it was last week. And that one will not tell me lady.
On behalf of the nine petitioners, my name is Lempa. We would also be seeking leave to amend the petition intending on what transpired at the Senate.
Mr. Lempa,
Yes,
what are you saying?
I am saying, my Lord, that we will be seeking leave to amend the petition depending on what transpires at the Senate, and will also associate ourselves with the submissions of Mr. T.K. Waduka because of the challenges we experienced last week on the CTS. If necessary, the ministry allows us to launch our documents physically.
My lords and my lady, my name is Simon Mburu for the aid petitioner. I associate myself with the submissions of the past 7 and the 9 petitioners, and also wish to seek leave to amend our petition as the courts have already appreciated the manner in which this matter is mutating, and depending on the outcome of the Senate tomorrow, would then necessitate putting an amendment to fully anticipate that outcome and have it brought before the court. That is all.
We don't want to close out anybody. Is there any person with further comments? Then we will consult on these applications.
My lord, for the respondent, I thought you are referring to the petitioners first.
All right.
For the response, my lord, on the applications that have been made by my learned colleagues on leave to amend, my lord, you shall note that there's been no disclosure on the would-be intended amendments that will be sought, my lord, to be incorporated if leave were to be granted. My lord, we want to avoid a situation where we will be faced with a totally new petition disguised, my lord, as an amendment to the petitions before you. In our humble view, my lord, there's a very good reason to request that if there is any party, my lord, who would wish to file an amended pleading, my lord, that they seek that leave formally by way of an application, so that then, my lord, the respondents will be given an opportunity to appreciate the nature of the would-be amendments and respond accordingly, my lord. To seek leave, my lord, in the nature that have been done, my lord, an open blanket leave would, my lord, be totally unfair to the respondent, as we do not know, my lord, how that leave will be utilized. My lord, we are therefore vehemently opposed to that application of leave to blanketly amend the petition. My Lord, there are rules that govern amendment of pleadings. And before you grant that leave, my Lord, you must be certified that that threshold has been met. None has been demonstrated, my Lord, by the blanket requests that have been made by our land colleagues. My Lord, on the other request that we mentioned this night on Friday, my Lord, I will refer you to the ruling that you delivered this morning, where you've been expressed, my Lord, that this court would provide a remedy at whatever time is moved appropriately. You've also, my Lord, stated that it will not be right for a party to anticipate or engage this court in speculation. To therefore, my Lord, seek a mention on Friday, my Lord, based on the same reasons of speculation and anticipation, my Lord, would be contemptuous, my Lord, of the ruling that you have delivered. My Lord, we had indicated before you yesterday that we have about 23 matters related to the consolidated petitions before. My Lord, we've hardly had time to, my Lord, engage in those matters. The petitioners before you, my Lord, have had their share of the judicial time.
Mr. Mulimo, if we were to know what we are going to say, we are going to limit the time because the applicants have not used the amount of time you have used in response.
Thank you, my Lord. I think, my Lord, therefore, I would request that you do not give them, my Lord, that request for Friday. That, my Lord, you allow this matter then to take its normal cue. And that, my Lord, we will be available to come back before you any other date, my Lord, next week for a mention. I should have known, my Lord, all our other colleagues are before the Senate. They are not here, my Lord. We do not have their diaries. We request, my Lord, that you decline that request to appear before you Friday. I thank you.
Thank you.
Lord, on the leadership, will be just 1 minute to respond to those issues. As regards the issue of amendment to the petition, Lord, at the time a petitioner is approaching the court for a remedy, we don't disclose essentially what the nature of the petition is. A party is free to file a case before the court and raise issues where the respondents then have a chance to respond. So that in case an amended petition, your Lordship, is filed, the respondent will not be prejudiced in any way because they will have an opportunity to respond to the amended petition. So that if the need is a change of the prayers or anything in the petition, then they will have an opportunity to respond to anything that could be introduced in the amended petition, so that there is no harm in allowing that particular prayer. And we have had an experience with this, my Lord, in a matter that was filed in Kiambu. When parties sought to amend a petition, Mr. Bilimo side opposed the amended petition on the basis that leave had not been granted. So to avoid all that, and noting that this is a matter that has very strict time constraints, we would think that it would be prudent that these courts allow at this time that we can file an amended petition. On the second issue, the mention of site, the outcome is two. The deputy president can either be impeached or the charges before the Senate might be dropped so that they are not confirmed. So that it will also be important for the court's program to know what is the outcome of this particular matter that is of great public interest. The mention on Friday will therefore help in updating this honorable court on the outcome of that particular process before the Senate, so that we either seek direction for hearing of the petition or we update the court as we are hoping that the charges will be dropped, that these petitions have then been overtaken by them, so that they don't continue holding the shares of the court. So that it is important that we don't spend a lot of time in getting directions for these petitions that are pending before the court. That is why the mention is urgently needed so that we can address that issue conclusively. Thank you.
On behalf of Yes, my Lord, my ladies, yesterday when we were online, I heard Mr. Milimo saying that parties are bound by their pleadings. And therefore, it cannot be had this morning to bar the same parties from amending their petition. My Lord, my lady, this court has powers and jurisdiction to guard itself from abuse by any party seeking amendment of its pleadings. And therefore, the submissions by Mr. Milimo are speculating that parties indeed intend to abuse the process by making or introducing matters that would render the petitions totally new. My Lord, my lady, I've had Mr. Milimo submit that advocates who are not present have no advantage of taking the directions that will be given. Every party that has been here has actually given an indication that they are holding grip of certain people. Therefore, no party will be prejudiced by any direction that will be given by this court. In conclusion, Mr. Milimo's opposition to the amendment of our petition is just filibustering of this matter. Because
what did you say? That one. It's just. What did you say?
it's filibustering.
Filibustering. What's the spelling? Filibustering.
Yes.
To?
Filibustering the matter.
What does that word mean? What is the meaning of that
word?
To stall the process.
Yes.
That's an easier way of saying
Yes.
it. Yes.
Delaying something without necessarily breaking the rules, what filibustering is. My assistant is a definition of filibustering, but I had looked at it before deciding to use it. So it's an opposition for opposition's sake. Nobody intends to abuse the process of this book by amending. We'll add a paragraph or thereabout, and he knows what is like. Parties have submitted, depending on what will happen in the Senate, they be given leave to amend their petitions or their respective proceedings. That does not amount to an abuse of the process. That's all we are.
Thank you. Do we have any parties online who want to comment on this matter?
My Lord, if I may just make one remark, and this one is for the benefit of Mr. Milimo. Last week on 11th of October, in Kerugoya, in petition number E014 of 2024, which is related to this subject, this issue arose before your brother, Justice Mwongo. And in a recent ruling, which we'll be getting a copy of today, Mr. Milimo vehemently opposed a similar application for amendment, and the judge made a ruling where he allowed these kinds of amendments. And what the judge said is that the mutating nature of this process necessitates constant updating and amendments. So this is not one of those cases where facts exist and they don't change. They change every day. So that by the end of today, by the end of tomorrow, the facts will be totally different. So let us leave that room open, at least up to the conclusion of the Senate proceedings. Thank you very much.
My Lord, for the record, my then colleague will confirm, I was not in Korogoya. I don't know whether I'm probably he must withdraw that, my Lord. I was not in Korogoya.
Sorry, my Lord, Mr. Namodi, his senior is the one who was leading the delegation.
Thank you.
My Lord, my lady, on the part, my name is Opola, for the third, fourth, and seventh respondent. On our part, we thank you for your ruling this morning, and we thank you for allowing the fourth respondent to proceed with the constitutional process before it. On the applications made by counsel for the petitioners, we shall abide by the directions of the system.
Thank you. Do you have any parties, counsel online, who wish to comment on the application for leave to amend petitions? If there's none, I think you cannot amend petitions except by leave of court, and therefore the issue which we have raised, we need to consult on it and give an appropriate ruling. We'll therefore adjourn for 20 minutes.
And that is news just in. The three-judge bench of the High Court declines to stop the impeachment trial against Deputy President Rigathi Gachagua. The judges, including led by presiding judge Eric Ogola, Anthony Mrima, and Frida Mugambi, have been deliberating the consolidated petitions seeking to stop the impeachment motion against Deputy President Rigathi Gachagua. The three-judge bench there terming the applications as premature and anticipatory, and saying the petition can proceed unhindered in the Senate, which is already in the House in Parliament, ready to debate.
Thank you, Madam Speaker. Honorable Speaker, pursuant to the provisions of Standing Order number 44, 2C, I wish to request for a statement from the chairperson of the Departmental Committee on Administration and Internal Security regarding the tenure and transfer of the Deputy County Commissioner for Garbatula in Isiolo South constituency. Honorable Speaker, the National Government Coordination Act 2024 provides for Deputy County Commissioner in respect of every sub-county, mandated with coordinating national government functions at the sub-county level. It is with great concern that I raise the issue of deteriorating security situation in Garbatula's Isiolo South constituency and failure by the Deputy County Commissioner and his team of the area to adequately address the issue. Over the past 5 years, residents of Garbatula have faced rising cases of insecurity and have persistently appealed to the Deputy County Commissioner, Mr. Stephen Nyakundi, to address the issue to no avail. This issue has negatively impacted the social economic lives of the residents, including a 5-year closure of Bisanadi Primary School, Korbesa School as a result of unmitigated conflicts between feeding communities in the region. Just recently, the Ministry of Interior and National Administration announced transfer of Deputy County Commissioners, including that of Mr. Nyakundi. However, in a quick turn of events, his transfer was reversed, which makes this the 4th time this has happened in the last 7 years. Consequently, this has sparked public outcry as the residents believe that the Deputy Commissioner has failed to fulfill his mandated duties, particularly in maintaining peace and fostering cohesion within the sub-county level. Honorable Speaker, it is against this background that I request for a statement from the chairperson of the Departmental Committee on Administration and Internal Security on the following. Reasons for the repeated reversal of the transfer of the Deputy County Commissioner for Garbatula, despite demonstrable failure by the DCC to end the persistent insecurity in the region. Number two, measures being taken to effect the transfer of the DCC of Garbatula in Isiolo South constituency and postal replacement. And number three, strategies put in place to enhance the transparency and efficiency of the transfer process of national government administrative officers to ensure that they are in a position to serve their assigned regions effectively. Thank you, Madam Speaker, for giving me the opportunity. Thanks.
The question shall be responded to by the Departmental Committee for Administration and Internal Security. Honorable Tongoyo. How much time?
Okay, of course, Honorable Speaker, when we come from recess, but with actually a lot of respect to the rule of the House and the Honorable Member, listening to what he was saying, this is purely a human resource issue that I think will not have really warranted to be put as a statement, because the Ngawa office, or the officers who are responsible with the issue of placement and transfers of our officers, their offices are actually open, and they do this based on merit on individual cases. So I would rather challenge or ask them, Honorable Member, if we found it fit, just get to the office of the Administrative Secretary Administration and discuss even the issue. It's more better even if approached in that manner.
Okay, I think he's noted that point, but nevertheless, because the member has sought a statement to this, just put in the request.
Well guided.
Yes, he's going to either have the committee will make sure they get the report, the response for you. So 2 weeks, Honorable Tongoyo? Okay, thank you. I know you don't have to wait after recess. You can actually send out, because the government is not on recess. So if you send out the letter today, then by the time we come back from recess, the response will be there. So you can't put the country in recess also. Thank you. The next question is by the Honorable Member, nominated Member Abubakar Talib. Honorable Bidu?
Yeah.
Yes?
I have tried to go to that office severally. 4 times the transfer has taken place.
Honorable, because you're out of order, allow him to proceed.
Where do I go? Can I be given assurance, Madam Speaker?
Yes. Honorable Member, I've already ruled that the chairperson will send out the letter today or tomorrow, and then by the time we come back from recess, there should be a response. So it's sorted out. Thank you. What's your point of order, Honorable Russo?
Thank you very much, Madam Speaker. Madam Speaker, I respect your ruling on this matter. But as the Honorable Chair has already affirmed, this is a human resource issue. And what the Honorable colleague is saying is this particular DCC has overstayed in that area. And as a result, the citizenry are up in arms, complaining. And that is why some things are administrative. They don't have to come to the floor of the House. But I believe as a committee, we will also pursue so that it doesn't really waste the time of the House when it can be done by the ministry. Thank you, Honorable Speaker.
Okay. Honorable Member, that's a point noted, but let's allow the relevant State Department to do that response to the member, not yourselves. Now you're acting like the State Department. I think if the member wants the response from